I think it's time to get started. Well, first of all, very big welcome to everybody, and thank you very much for giving up your time and joining in our webinar today. As we've said, this is the first of a two-part webinar series. The first today being the overview of basic principles and commonly encountered issues in employers' liability claims. And this is going to be followed up by webinar 2, which is going to be specifically about coronavirus and employers' liability. The reason we're doing it like this and why we thought that would be a helpful way of doing it is because, of course, the coronavirus pandemic raises an awful lot of issues for employers and for employers' liability claims. But this is a novel area, and at the moment, we don't know exactly how the courts are going to deal with all of the issues which are going to arise. And our view is the best way to address that is by going back to basics, as we're hoping to do today, to examine the fundamentals of employers' liability, to refresh these issues in our minds, to then have the framework in place to consider how the very specific and novel issues from the coronavirus pandemic are likely to be dealt with by the courts. So as I say, this is the Back to Basics session, and we're going to be following up in due course with the in-depth coronavirus session. But we'll be touching on coronavirus issues today as we go through. And we've had some questions in already, which we'll do our best to answer either as we're going through or at the end, when we're going to be doing a Q&A as well. And please, can I encourage you, if you have questions, to use the Q&A function, which you hopefully can see on your screen. And the session's supposed to be interactive, so please do feel free to ask your questions as we're going through, and whichever one of us is speaking at the time will endeavour to deal with them either, as I say, as we're going through or at the end. And thank you very much to the people who've put their questions in already. And on that point, I'm going to hand you over to Ben, who's going to get us started.
Thanks, Andrew. Good morning, everybody, and it's fantastic to see so many of you in this, what's still, for me at least, very unusual format. I'm going to start by looking at some of the questions we're going to be answering in the context of this session. They're really trying to explore some of the particular issues which arise in relation to employers' liability claims, and also the way in which, on a practical basis, we handle them on a day-to-day basis. So I'm going to be starting by looking at what the causes of action, cause of action which now exists and is available to employees, obviously with consideration of relatively recent developments in 2013, before turning to look at who can actually bring a claim against an employer. And no prizes for the obvious. It is actually can be cast slightly wider than one might think. And the ramifications of that are perhaps a particular import, and given everything that's going on at the moment, I'll return to that. Before I do, I'm going to talk about the 4 central tenets, or the 4 fundamental aspects of the employer's duty to an employee, and how, in fact, regulations might assist us in framing those so as to analyse the case appropriately. Andrew's then going to go on and look at some of the practical bases and the evidential considerations we might want to think about in dealing with these claims, and looking at how the court might approach a particular matter. I will then touch on the question of causation in the context of employers' liability. It will only be touching on it, for reasons I'll come to, before Andrew goes on to look at contrib and indeed complete defences, other obviously than avoiding a finding of breach of duty, which are available to the employer. And after that, as Andrew's already touched upon, people have already been kind enough to send in some questions, many of which have a virus-related theme, notwithstanding the fact that we're going to be looking at that in more detail in a couple of weeks. And so I've sort of drawn those together, the frequently asked questions, as it were, and we'll just give an outline of where we are at the moment, and the position, of course, possibly being completely different in a week or two's time. So if we can then therefore go over to look at the first of those questions, what are the causes of action now available? I've touched upon, mentioned the Occupiers Liability Act simply because one sees it pleaded. I don't think it adds anything in practice. In reality, the extent and the scope of the duty arising in negligence as between an employer and employee is going to be more extensive than under the Act. But I mention it simply because, as I say, in practice, one does come across it more than I think it probably merits in this context. I've already touched upon the significance of the Enterprise and Regulatory Reform Act back in 2013 and Section 69. And of course, the significance of that was it meant from, as of the 1st of October that year, breach of duty imposed by what we described as health and safety regulations, and we're talking here, of course, of the six-pack and COSH, no longer provide a standalone cause of action which an employee can rely upon. So what really are we left with? Well, an employer's liability claim is a personal injury claim brought in negligence. In one sense, no more and no less than that. So why are we talking of them in this particular context, and if there were a particular species of claim? Well, I think there are a couple of reasons for that. They are unusually extensive in terms of the duties they involve, and of course, this being a related point, they also arise out of an unusually proximate and in some senses intimate relationship. They also have some particular features which have developed through case law as a result of that. And it's for that reason that we do talk of them as being a particular class of case. But of course, ultimately, as I say, we are talking about, in inverted commas, a normal PI claim, albeit with those special qualifying features. But that takes me on to the next thing I'm going to talk about, which is who can bring such a claim. Well, before I get to that, I'll just touch upon this. The regulations are, of course, still in existence, and that is of considerable import. Had Parliament intended them to have no significance in assessing the standard of duty required, one can only presume they'd have been repealed. They haven't, and the reason that's important is that what it has allowed is the development of a line of reasoning which asserts that the fact that the regulations are still in existence, not being repealed, and of course still impose criminal liability for many breaches of them, in fact. It's possible to say that an employer whose the standard of care in respect to their employee being assessed in negligence cannot have acted reasonably where there has been a breach of those regulations, and sometimes the potential for illegality to have existed. So on first view, that leaves us with a position in which one might say, well, what's really changed? Because if we're going to say, well, the extent of the duty of care is essentially the same, it just exists in negligence, what difference has it made? And to a point, I think there is some force in that. But there have been changes, and of course, the flip side of the continuing existence of the regulations is the fact that we now have Section 69 as well. And presumably, if Parliament had intended there to be no change to the position, it simply wouldn't have enacted that section in the first place. And indeed, it would be odious if nothing had changed. So what has altered? Well, one class of case which has disappeared are the staff and post office type cases. So latent defects in work equipment, it's no longer possible to bring a claim on the basis of strict liability. Another area of significance is, of course, that the burden has shifted, and it will no longer be the case that an employer finds itself having to demonstrate it was not reasonably practicable to do or not do some particular step. And another of all that is that we're now concerned with fault-based liability. It's for the claimant to identify and prove, according to the usual standards, fault on the part of the employer. So there has been a change, but it's perhaps not been as significant as back in early 2013 we thought was going to be the case. But there certainly are cases which have been affected. So, moving on once again, if I may, who can bring a claim of this sort? No prizes, as I've already said, employees can. There are, however, other classes of persons who can potentially bring claims arising out of the originally out of the employer-employee relationship, the workplace environment. And these are the secondary exposure cases, the vast majority of which deal with asbestos exposure of one sort or another. And the first line of authority among these involve members of the family of people who've been working in asbestos-related trades, who've been exposed by reason of those people, you almost invariably men in those days, coming home and bringing their clothes and their contaminated overalls with them. And members of the family who came into contact with that were similarly affected by dreadful diseases. And it's been established that a duty can exist to those people, members of the family. Similarly, in relation to the situation in which we're considering a potential duty owed to an even wider group, members of the public or some class thereof, arising out of the cases in which children played, unbelievably as it now seems, in piles of asbestos which were allowed to accumulate in the street. And as a matter of principle, it's clear that a duty can be owed to that relatively wide group. It is worth sounding a note of caution here that whilst we're looking here at the existence of the duty, it doesn't follow that because there was a breach vis-a-vis the employer and the employee, that proves it to be the case in respect of a wider group of people. And again, looking at the asbestos cases, whilst we see from sort of 1965 or thereabouts, employers being treated as being in a situation where they should have been on notice of the danger of employees being exposed to asbestos. It wasn't until later still that medical knowledge advanced such that it was appreciated that the wider public or indeed a family could be exposed in that secondary fashion. So one needs to look very carefully as to how the breach arises, not just at the existence of the duty in those cases. I talk to what might seem a fairly specialised group of cases that to a greater extent than perhaps would have been the case if we'd been here 6 months ago, simply because I do wonder whether this isn't going to be a line of argument which is significant in terms of people arguing that they've been exposed to coronavirus by some not immediately proximate cause. And that's something we're going to be coming on to next time, but it's for that reason I'm talking about the basic principles here. Flip side of all this, who cannot usually bring an employer's liability claim? Well, it's quite clear that many people can't. And for instance, the employer of an independent contractor doesn't owe that duty to a contractor. And there's a whole list of doesn't owe I could go through. But there is one subgroup, and in practice, it's quite an important subgroup of people who can in fact assert that they are, for these purposes, effectively an employee of a particular entity. And that arises in the situation where, to put it more colloquially, a worker is on loan to a head contractor. And the reason for that is because of the degree of control which the hiring, the head contractor has over the way in which the hired employee works. There can be some interesting ramifications of that in terms of where it leaves liability. And just to explore that, perhaps if we consider, and by analogy on one of the leading cases, a common situation, a mini digger and its driver being hired out to a building site. If we have, for instance, the digger turning up on site and then catching fire because it's not been serviced properly, something catches and up it goes in flames, it's pretty obvious that the employer of the digger, the owner of the digger, and the person responsible for its maintenance and servicing is going to be the person in the frame. There's no operative fault on the part of the hirer, and he had no control over the material issues. But let's take another example, perhaps going completely the other way. If the mini digger turns up on site and is set to work going backwards and forwards over some old excavations which haven't been properly filled in, mini digger disappears into the excavations and the driver's injured. Is it then appropriate to point the finger at the employer? Arguably not. The reason being that, of course, he would have had no control over the fact that his driver had been set to work in that way and had been set to work in a workplace over which he had no control. So in those circumstances, it can be more than possible to bring a claim against, depending on the facts, against that hirer and he will be treated as being the employer of the injured person for those purposes. And it's worth noting here that the degree of proximity and control necessary to satisfy that test is in relative terms fairly low. It's nowhere near as high, for instance, as the degree of control required to bring somebody within the realm of vicarious liability. And the touchstone really is whether or not the person against whom one's pointing the finger has control over the circumstances giving rise to the accident. So whether it's the work equipment that's at fault, the place of work, who actually in practice was in control. This can be quite significant in practical terms, not only because the circumstances are, I think, more commonly encountered than one might think on first glance, but because it can be useful where, for instance, one of the potentially interested defendants is a man of straw. It can also be worth thinking, both as claimant and as a defendant who has a view to another party being co-defendant, how the claim might be framed, and indeed how one's position as a defendant might be asserted, particularly in circumstances where, in respect of the claim as against one of the employers, there may be differing merits to an argument of contributory negligence. So that's always worth having a think about in practice. All right, well, that brings me to the next thing I'm going to talk about, just going over, which are 4 central tenets of the employer's duty. I'm going to start here by saying we're not talking about 4 duties. We're talking about, in essence, a tool by which one often sees the employer's duty analysed in terms of its scope and extent. And there are 4 broad pillars to that. The first is in respect of safe staff. In essence, the employer needs to provide suitable and appropriately trained co-workers for the employee to exist alongside. Failure to do that has obvious ramifications. There needs to be a safe place of work. And it's worth noting here that this isn't limited simply to the place of work. It's cast wider than that, and it involves access to the place of work as well. Safe work equipment, again, is drawn widely. It encompasses not only things which the employee might be working on, for instance, if he's using a press or a lathe to work on a piece of machinery or a piece of metal or something, that will be treated as within the work equipment. But also of huge significance, and particularly topical at the moment, is the fact that it also encompasses PPE and the suitability of that, whether or not a cost regime is engaged. And finally, and arguably as an overarching principle here, we have the safe system work. And this covers everything from both the minutiae of the instructions given to an employer about how he or she should go about her work, to the broad design of the workplace, the system of work which is being operated, and the way in which the employer is working. It's worth, I think, making clear that one doesn't have to constrain an allegation of breach to one of those heads. And it's in no way problematic, never mind fatal, if it's not possible to do that. And indeed, some broad allegations of breach, that's in relation to manual handling, might arguably be said to engage several at one time. We are talking here about breach of a single duty, but this is a useful way in which to analyse it and a useful way in which to frame the analysis of any wrongdoing or suspected wrongdoing on the part of an employer. Now, but the final point I'm going to make before, for the moment, I hand over to Andrew, is this one. It relates to a particular feature of employer's liability. It's the fact that the duty is non-delegable. And what that means is that performance can be delegated to a subcontractor, but liability does not go with it. And the effect of that is that the employer can be liable even where the operative fault is not its own. What I would, however, highlight here, because again, this is something which it seems often to be misunderstood, that doesn't mean that liability is strict. It's still a fault-based regime of liability. It's simply that the liability for non-performance or negligent performance cannot be delegated. The claimant still needs to be able to prove fault in the usual way, whether it's against the employer or against the contractor complained of. But often, as I say, there seems to be something of a misunderstanding that somehow employers are fixed the responsibility for anything that goes wrong in the context of the work environment if somebody else is responsible. The rule is not quite that extensive. Now I'm going to pause there and drink some tea, and Andrew's going to take over before I come back in a bit and talk for a short time about causation.
Thanks very much, Ben. Perhaps before we hand over properly to me, we've had a question in which was exactly on the non-delegable duty of care. So this is from Joe, and if I read the question out, then it says, what about the situation where a council is contractual employer, but the employee works in a school run effectively by the governing body?
I must confess, Joe, I'm not absolutely sure about that I understand the situation, the significance of the situation you're describing. If the council is the employer in the usual way, and the school is being run by the governing body, then the position of the governing body, absent anything else, would be simply analogous to senior management, and therefore it would make no difference to the usual rule. If the governing body, and I think I do know the sort of situation you're talking about, the governing body perhaps isn't the right way to describe them. If the school is being effectively run by another legal entity, if I can call it that, then the situation in this context would, I think, depend on the way in which control of the school environment had in fact been set up. It would also depend on the nature of the relationship between the individual and the governing body. And oh, hang on, I'm going to pause because something. Okay. I think I see. What Joe has said is he mentioned. I think he's talking about the context of risk assessments in reopening schools. I'm not sure, Joe, that's this is necessarily the point to come back to that. And I think, if I may, I will return to that point in the context of the questions we're going to talk about at the end, just because I don't want to repeat everything which I'm going to say therein now and then have to go back to it. I am here a bit mindful of the time as well. I hope that makes sense.
Thanks, Ben. Well, as Ben mentions, if I can make the PowerPoint go on, yes, I'm going to be talking about the standard of care. So, as we've been saying, this is a negligence-based liability. It is not strict liability. However, it has been expressed in a number of cases as being a high duty. Now, we've also heard about how this interacts with the duties under health and safety legislation. And health and safety regulations often refer to reasonable practicability. And looking at the standard of care here requires thinking about what does reasonable practicability mean for the purpose of whether you've complied with a statutory duty, and how, if at all, is that different from the employer's liability in negligence. Well, in Edwards and the National Coal Board, the court said that reasonable practicability, when something is not reasonably practicable, then there's a gross disproportion between the risk and the measures necessary to avoid the risk. So the measures being grossly disproportionate compared to the risk. And according to the Court of Appeal in Edwards, that is when something is not reasonably practicable. And it's been said that makes it very clear that there is a big difference between the duty of care at common law and reasonable practicability under the regulations. And what this means then is that not all breaches of regulations, regardless of strict liability ones, are necessarily going to mean that there's been negligence by an employer. And you've had a court say that in a case called Cockerell and CKX, where the courts noted that by repealing civil liability for health and safety regulations, Parliament had intended to make what they called is a perceptible change to the legal relationship between the employer and the employee, and that it wouldn't be the case that all breaches of regulations would be regarded as negligent. And I think analysis of what reasonable practicability means is certainly part of that. Going back to reasonable practicability for a second, what happens if you have made some changes after an accident has happened? Can you still say that it wasn't reasonably practicable to avoid the accident first time around? Well, it seems to me it's quite difficult to say that. There was a recent case about deafness caused in the Royal Opera House. This is the case of Goldscheider. And a viola player contended that they had suffered hearing loss as a result of rehearsing very loud Wagner. And the Royal Opera House argued that it wasn't reasonably practicable to avoid the incident, essentially. However, afterwards, they had reconfigured how they run rehearsals, and it essentially managed to significantly lower that risk. And the court said the fact that they were able to do this differently after the event meant that it wasn't that it was reasonably practicable to have done that earlier. So reasonable practicability, unlike the common law test of foreseeability, can be judged with hindsight. So that's another factor to think about with the difference of these two. I would also say that another example where these aren't coextensive is that if you have complied with statutory duties, it is still theoretically possible to be in breach of common law duty. And although, because the statutory duties are so wide, it might be quite difficult to imagine how that would be possible. But there have been some cases where that's been the case. There's one called Bucks and Slough Metals, which I'm going to be talking about in a minute, where there'd been compliance with statutory duties relating to PPE, but what there hadn't been was proper enforcement of the requirement to wear PPE. And on the facts of that case, the courts held that there was no breach of statutory duty, but that there was nonetheless negligence at common law. So moving on then to particular relevant factors. And the first one that I mentioned here is industry practice. And the importance of this really has been teased out from industrial deafness cases, because for many years, the practice in industry was really that they weren't aware of the risks that could happen from noisy machinery to people's ears. And industry as a whole took some time to appreciate the risks and then deal with them. And we can see that from a relatively old case now, Thompson and Smith's ship repairers. There had been a long general practice of inaction to do with these risks, and it was only once employers had the relevant knowledge that they could be held to be in breach of duty. And I think that's going to be very relevant to our current situation, because as I said at the beginning, all of the issues to do with coronavirus are extremely new, and we don't know exactly precisely what has to be done to avoid exposure, if that's even possible. And the relevance of industry practice and industry knowledge is going to be important, I think, in COVID claims, which does take me on to one of the factors I've got at the end of the list there, which is compliance with guidance. Because of course, when it comes to what industry knowledge is or should be, official guidance, HSE guidance, is going to be extremely important. And I think at this, particularly given all of the known unknowns and perhaps unknown unknowns, to lapse into Donald Rumsfeld for a minute, complying with industry guidance is essential. And if you don't do that, you can anticipate that a court is not going to find it particularly difficult to find that there's been a failure to take reasonable care. Aligned to this is the question of the knowledge of this particular employer. And the issue there is, it's not a defence for an individual employer to say, oh, I didn't know about this particular risk, if the industry as a whole did know. And in a particular case where you have an employer who doesn't have knowledge, that may well be evidence of a negligent failure to risk assess, because they are obliged to do an assessment and to consider all of these risks in a proactive way. We've had two questions I can see about risk assessments, which I'll attempt to deal with when I come on to the risk assessment section. So knowledge of the employer is that. What about circumstances of the individual employee? Well, the duty is owed to employees as individuals rather than a collective. And what this means is the employer's got to take heed of the fact that some employees may be particularly vulnerable. And I think that's going to be particularly important in the context of coronavirus, because we have whole categories of people who are vulnerable by reason of age, pregnancy, a whole series of underlying conditions, many of which are actually quite common among the population. So it's important to remember that each claim is by a single employee, or if it's a group, they are individual claims by those employees, and the duty is owed to them differently. And the way to comply with that duty may be different for particular employees. Then the question of risk assessment, the importance here is that regardless of the management regulations which impose statutory obligations to risk assess, the common law says you also need to do a risk assessment. And in a case called Kennedy and Cordia from 2016, the Supreme Court emphasised that all prudent employers will do a risk assessment. And the purpose of that is so that you can then identify what you need to do to protect your employees from these risks. The risk assessment forms, as the Supreme Court said, the context in which the employer has to take precautions in the exercise of reasonable care for the safety of its employees. Now, we've had a question saying, does pleading that there's been a failure to risk assess actually add anything? And my response to this is, well, a risk assessment, failing to risk assess, is never going to be causative by itself. But in many cases where you have a relatively unusual risk, what I think a claimant wants to be able to do is to put in place the building blocks to say that the employer should have identified this risk. And given that there's an obligation to risk assess, if you have something quite unusual that's happened, then the employee wants to be able to say, you should have risk assessed and you didn't. And had you in a breach of duty. Now, check that you can still see me, because I've got a sign on my screen saying my connection's been lost. Can you still see me?
Andrew, if it helps, I can see you.
Can you not see the PowerPoint? I think the PowerPoint's come back now. I've had a whole lot of chats. Hang on a second. Let me see whether anyone's. It's back on now. Yes, thank you very much. I'm not sure what happened then. The internet in North London is obviously less good than the internet in the Isle of Wight, where Ben is. So apologies for that. So that's risk assessments. Foreseeability, though, if the harm was truly unforeseeable, there's going to be no breach of duty, and it's foreseeable. It's sufficient if foreseeability if the same type of injury is there, then you can make out a case. But if something is truly unforeseeable, then there isn't a breach of duty. Just because you change a risk assessment after an accident doesn't mean you were negligent not to have assessed this risk before. And a particularly arresting case on this is Shelbourne and Cancer Research UK. And this is an accident where somebody was injured by over-vigorous dancing at an office party where some alcohol may have been consumed. And the employee sued, saying that there hadn't been a proper risk assessment because the risk of vigorous hand gestures during dancing hadn't been assessed. After the accident, the risk assessment had been changed to identify the possibility that an inebriated employee might act dangerously on the dance floor. The claimant said, you should have assessed this risk beforehand. And the court said, no, it wasn't foreseeable beforehand. Context is all important. Previous parties hadn't given rise to any similar behaviour, and you can't criticise the employer for not foreseeing this. And simply because you change the risk assessment afterwards, that's the actions of a prudent employer. It doesn't mean that it doesn't automatically prove that you were wrong not to have done it first time. One question that we touched on earlier when Ben was speaking was about control, and an issue that arises is workplaces and who precisely they're under the control of. And where you have somebody's employee working in somebody else's premises, then you may well have a situation where both the employer and the occupier of the premises are liable if the premises are dangerous. The employee is going to have an obligation to devise a work system which is safe for the premises that the employee finds himself in. So if you have a window cleaner, for example, working in lots of different premises, might have all sorts of risks relating to the different premises. The employer hasn't got control over those premises. But what they do have control over is the system of work, which should be safe for the premises that the employee is working in. This comes to the question of training as well. And clearly, there has to be a reasonable system of training so that the employee is able to do their work in safety. And a particular factor about individual items being broken or in an unintended state. It's important to remember here that there used to be strict liability for work equipment under the Staff and Home and Post Office, but that doesn't apply anymore. If you have a latent defect, that now is going to be a defence for an employer. But equipment going wrong automatically raises questions of, was it a properly specified piece of equipment? Has it been properly inspected and maintained? Because it's relatively unusual for there to be a true latent defect where something breaks without any fault on the part of anybody. I'm going to move on because I'm conscious of the time, and the next slide, if I can advance onto it, are specific circumstances, and we've got on there manual handling, work equipment, and COSH. And in manual handling, this is where it's quite useful to go back to the regulations and remind ourselves that the first duty of an employer is actually to avoid the need for manual handling altogether. And the duties about risk assessment, reducing the risk of injury to the lowest level reasonably practicable, and providing information about the load only apply where it's not reasonably practicable to avoid the manual handling altogether. When you're doing manual handling, the weights are very important. There isn't any maximum specified weight, but the heavier the weights, the more control measures are likely to be required to enable the employee to lift those in safety. There's also the question of repetition, because the more repetition there is, the more likely you are to get injuries such as hernias. And indeed, the conditions in which the employee is having to work, because if the conditions are cramped, or if there are items in the way, then they may be having to adopt an unergonomic technique, which may have a higher risk of injury. So these are all things to particularly be aware of in a manual handling case. In a work equipment case, I referred earlier to latent defects and how when you have a damaged piece of work equipment, the question that immediately will arise is the regime for the repair and maintenance. And records, because it's very difficult for an employer to prove that there's a reasonable system of inspection and maintenance if there are no records to show it. And that's something where documentary evidence is going to be crucial. There's also the question about whether the employee is using the equipment in the way that he or she was intended to do so. That takes us back to training and enforcement. If there is some practice of using inappropriate work equipment in some inappropriate way, there's a risk for an employer that they may be said to have condoned some unsafe system of work or improper use of work equipment. Finally, on this slide, the question of COSH. This, again, is an area where there's no civil liability for breach of this, but courts are going to be looking, I suspect, very carefully at the COSH regulations to see what a reasonable employer would do. And here, the primary duty is for employers to prevent exposure to employees of substances hazardous to health. And that's the primary duty, actually prevent exposure altogether. And it's only where that's not reasonably practicable, that we have the question of control. And when we're looking at adequately controlling exposure, again, there's a cascade of measures that employers should take. And we all immediately think of PPE, but actually under the regulations, PPE is the secondary control measure. And before using PPE, employers should consider designing work processes, systems and engineering controls to avoid, to adequately control exposure, or to control the exposure at source, including adequate ventilation systems and adequate organisational measures. And it's unclear the extent to which coronavirus is really going to fall within the COSH framework. I think it's going to depend very much on the particular employer and the particular task they're doing. But it seems to me that coronavirus is a substance hazardous to health potentially within the regulations. And it's interesting to see there that the sort of guidance that we're having about ventilation systems and organisational measures, such as how people move around a workplace and how much people come up into context with each other, is here as a more important on the hierarchy than PPE. And I'm now going to hand you over to Ben, who's going to talk about causation.
Thanks, Andrew. I'm going to be very brief on this topic, not only because I'm mindful of the time and eating to everyone's day, but also because in many respects, the rules of causation are applicable to employers' liability in the same way as they are to PI claims generally. And we've tried this morning to focus on things which are particular to this particular class of claims. But that's not to say that there aren't particular issues in respect of causation in terms of employers' liability claims, and I've identified two classic examples of that. I think we may be coming to a third class of such claims arising out of the coronavirus pandemic, and I'll touch upon that, as I've already said, in the answers to the questions. There was, however, one point I was going to make in respect of causation, and it's an entirely practical point. It's not really a matter of law. And funny enough, it picks up on one of the questions we had, which Andrew's in many senses already answered, as to the significance of risk assessment. And the point I was going to flag up was simply this. When one faces a claim or is looking to prosecute a claim in which there's a failure to risk assess, don't simply fall into the trap of thinking that that's sufficient and that's going to get the claimant home. I think it's right to say that in one sense, the question of the risk assessment is frankly neither here nor there. What makes a difference is what was or was not happening on the ground, whether as a result of it or not. So in response to the question we've had, yes, I think one can sensibly say it isn't something which actually needs to be pleaded because of itself. It doesn't take the claimant anywhere. I think it is, however, tactically significant in that most courts will find it unattractive if a particular situation has not been risk assessed. But it doesn't follow from that it's always impossible to break the facts of the case down and say, well, if it had been risk assessed, would anything have happened differently? And sometimes the answer is no, it wouldn't. So do look out for that particular scenario. But as I say, with 9 o'clock, that's as much as I'm going to say before handing back to Andrew.
Thanks, Ben. Well, I'm going to very briefly touch on contributory negligence. It's important to remember when contributory comes up that the courts have generally been relatively reluctant to impose contributory negligence in employers' liability cases. That's particularly been when it's been a breach of statutory duty. The reason for that being that the statutory duty is often there to protect employees from the risks of inadvertence in the workplace. And the balance that's been set by regulations has been to a large extent to protect employees from the consequences of their own human error at work. And the courts have been concerned that if they're too ready to make findings of contributory negligence, then that might undermine the purpose of the duties that are imposed in the first place. Now, today we're not talking about civil liability for statutory duties anymore, but the principle behind that remains the same. When you're looking at the relative how you should split liability between parties, then you look at the causative nature of the alleged breach by both parties, but also the question of moral blameworthiness. And in that context, the fact that this is an employment relationship is always going to be important. So it remains the case that mere human error, aberration, lapse in attention by an employee who perhaps is doing something very repetitive is not necessarily going to be enough for contributory negligence. And you normally need something a bit more than that. And by the same token, deductions usually are quite small, although not always. I have successfully managed to get a much larger fine for contributory negligence than 25 to 33%, but it's very, very unusual. The final thing we're going to talk about before we go on to the Q&A are other defences. And as it says on there, there's valenti, there's ex type causa. Both of them are going to be very unusual in practice. One of the most useful defences, though, is where the only reason that there's been a breach of duty is because of what the employee has done. So, for example, a state of affairs may have come about, which is a breach of statutory duty, but this has only and solely happened because of the claimant's conduct. You might also have a situation where the claimant is actually the person who's responsible for doing the thing that's being done wrong, such as the claimant is the company's health and safety manager. I've done a case where the claimant, who was the health and safety manager, tried to sue for the system of work that they said was unsafe, but that was their responsibility to actually come up with the system. There's also an example in a case where you have a claimant who is basically a one-man band. So you have the company corporate defendant, but in reality, that only is the claimant. He's the sole director and shareholder, and he is injured because his own company takes zero care of health and safety. But actually, he is the only person who could have done anything to make the party comply with its obligations. So the courts found in that case that the breach was wholly caused by the claimant for having a totally cavalier attitude to health and safety, and that his conduct is what it was that had caused the defendant, his company, to be in breach, and so dismissed his claim for his own injury. But all of these defences are going to be relatively unusual in practice, and I think Ben and I both agree that the best chance is to avoid a finding of breach in the first place. So on that note, I think we should move over to the Q&A. And so we've had a number of questions as we've gone through, where I think they've been answered. I've marked them as dismissed. So if I've dismissed your question, then please don't take offence. That's just to make it easier for us looking at the questions that are on here. We've had a question here from Michael Davies, who's asked about the burden of proof. Can you see that question, Ben, if you've got the interface?
Yes, I've got that, thanks, yeah.
So Michael's asking whether the burden remains on the claimant to prove causation at common law, or whether the court will assume in the absence of evidence from the employer, in some cases, that a failure to provide, e.g. training, was causative. I mean, I would say in response to that, that the burden is always on the claimant. And however, in certain circumstances, the court might be willing to draw an inference in the claimant's favour about the lack of something or something else that there should be. But we should never lose sight of the fact that the burden is always on the claimant to prove that causation. I don't know if there's anything further you want to add on that, Ben.
No, I think I would agree with that. I think I would say, Michael, that the sort of approach that you're postulating is one which, unfortunately for many claimants, disappeared as of the 1st of October 2013, and that, as Andrew said, while there might be circumstances in which perhaps factual inferences would be drawn, maybe in support of evidence given by the claimant himself saying, well, I didn't know that and I couldn't do that because. But I don't think one should really look to analyse these cases in terms of saying the defendant hasn't provided a satisfactory explanation, therefore we can assume that the accident would have been avoided. That's probably pushing it a bit too far now, I think.
Now we've got feel free to put more questions in if you have them. We've got a question here about secondary exposure. Oh, well, someone said we've had some connection issues. Will we be circulating the slides? Yes, we will. So don't worry about that. And we've got a slide at the end with case references to things that we've been referring to as well. So So yes, don't worry, we will certainly be circulating the slides.
Before we do that, I should just deal with Joe's question, which I did promise I would come back to, as well as talking about the virus issues. Joe, I've had a chance to have a look at what you said now, and I think if I've understood you correctly, the answer would be yes, that the council would remain in the frame, and very probably for reasons going beyond the context in which you originally asked the question. So I wouldn't worry about that. But yeah, I think the council would remain liable, would be my answer.
So we have another question on here, which is about secondary exposure. So stress-related claim by an employee, and then his or her partner going on to suffer another illness as a result of the stress of the first party, and whether this is too tenuous a link. Now, this is an unusual situation which I've not had to think about before. My instinct is that that is going to be too tenuous a link, but Ben, you're moving your head.
I was just about to reply, and I've just noticed that it's appeared on the chat. It says we lost sound.
Oh.
Can anybody still hear us?
Oh, a lot of people are saying they can. Anne, can you still hear? Oh, I think the sound's back on.
Thank you, everybody.
Thank you, everybody. It's much appreciated letting us know.
Yeah, it's we've nowhere known. So, thank you. Right, going back to where we were. This is an interesting point. I wonder if this is going to arise in the context of coronavirus-related claims, because there will no doubt be individuals who are concerned, not only by the prospect of their loved ones becoming ill, but by the prospect of them bringing it home and potentially infecting a wider circle of people. And it's one of the things which I'm going to be talking about sort of next time out. The short answer is I think they're going to be very difficult cases to win, not only because of the issues generally in relation to coronavirus claims, and as I say, I did promise I would say a few things at the very end, and I will, but also because the stress at work cases in themselves are very difficult cases to win, and the principles applied are exceptionally restrictive. So I think I would say in theory, no, it's not too tenuous, but it would have to be on, I think, relatively specific facts. And probably as a matter of policy, I suspect the courts would look to draw the line around such claims fairly narrowly. Andrew, what do you think?
Yes, I am not aware of a case like that succeeding so far, and all of the questions about foreseeability, which are so difficult for stress at work cases anyway, would apply to the partner too, because it would have to be foreseeable to the employer that if the employee became ill with stress at work, that it would then also cause his or her partner to do that. And I think that would be an enormous problem for a case like that. But yes, it's an interesting area. It is 5 to 12 now, and we don't have any more questions. So I think it's probably time to wrap it up. But thank you all very much indeed for attending. Thursday, 28th of May, our colleagues Sarah Prager and Richard Collier, who are going to be doing a talk about the future of the travel industry, risk and responsibility. So that's next Thursday. And we are going to be in a couple of weeks. We don't have the precise date yet because we've got some diary issues that we have to work out, but it's going to be in a couple of weeks. It'll be soon. Watch this space and we'll let you know when it is. And yes, thank you very much for listening to us this morning.
Absolutely, thanks so much, and I hope it was some use.